Thank you very much, Andrea, for giving us not only IP tools, but alternatives to IP, like blockchain, in relation to traceability and management of food systems. So thank you for that. Next are a duet, or duo, what should I say, of an assistant professor, Giulia Priora, at the Nova School of Law, Lisbon, and her PhD student, Amanda Costa Novaes. Do I pronounce this correctly? Yes. There you go. The floor is yours.
Thank you. Yeah. Perfect. Well, sorry. Yeah. I think I can talk. No. I think you hear me, and with the presentation, my voice stables. No worries. Thank you, everyone. So, hello, everyone. I would like, first of all, to thank the organizers for this event, Professor Geiger, but also everyone involved in it. It has been really well organized and an amazing experience. But without further delays, because we know we are the last ones in this morning, I'm Amanda Costa Novaes, this is Giulia Priora. We are both based in Lisbon at Nova School of Law, and we are part of a research center called Nova IPSI, that stands for Intellectual Property and Sustainable Innovation. We may look similar, but you'll see when she starts talking that we talk at least very differently and with very different accents. But without further delays, we are here to present to you about our ongoing research on rethinking morality in intellectual property to promote a sustainable innovation. And our roadmap today is basically the title of our presentation. So we are going to explain, first of all, why we chose this concept of morality and how it exists within IP law. And then we are going to advance to our rethinking of this concept and how this relates for a sustainable innovation to promote this sustainability. So first thing first, why morality? Well, there are actually two reasons why we chose this topic. Well, the first reason is actually because there is a conceptual compatibility between the concept of morality and intellectual property law. And this has been widely acknowledged because from the justification theories for intellectual property law, it stems that we don't want to incentivize creation that basically does harm to society in the end. And this is the first more scientific reason why we chose morality as a concept within IP. There is also a second reason, and this one is more personal. So within 2 years with Nova IPSI experience, we have been gathering empirical notes of this concept of morality surging, because each researcher has the power and the freedom to choose their research lines within this umbrella of intellectual property and sustainable innovation. And what we've seen is that a little group of researchers have been forming, looking at immorality from different perspectives in different IP branches. So we have researchers looking into the immorality of subject matter of IP law, for example, harmful works in copyright law, or the immorality of exploitation of intellectual property rights, for example, impediments for tech transfers. When you have a gray zone, there is not a violation of international law. And you have also researchers looking at the immoral consequences of IP exploitation. For example, the incentive to waste instead of incentivizing the reuse, recycle, and repair culture. So this is our empirical observation, but we are also talking about morality in IP because it already exists. So in a sense, morality is nothing new. It is constantly present in IP law as a mechanism to exclude from IP protection. And we've seen it in patent law. For example, in Article 27.2 of the TRIPS agreement, it clearly states that signatory members can exclude inventions from patent protection due to the harm they cause, if they are against public policy or morality. And they use, as an example, the prejudice to the environment. In Paris Convention, we have the same thing for trademark law. And here the example are trademarks that deceive the public. So these trademarks can be considered immoral or against public policy. And maybe you would expect me to give you international agreements and black letter law for all of IP branches, but there is none. And here we started to get more creative, and we started to look at supranational and national decisions. And in design law, we could find these decisions, then these legislations. In, for example, all EU national legal systems, we have a moral limitation, and this is also in Article 9 of the EU Community Design Regulation. So within the EU, we have this article that also excludes from design protection inventions that are immoral or against public policy. And in copyright law, things get even trickier because we couldn't find yet legislation, a codified law excluding these creations from copyright protection. But what we have been observing is a bunch of case law forming within this concept. So both nationally and supranational. And I brought you here two examples for different reasons. The first example is Hyde Park versus Yellen. It's a case from the UK, but it's here because it has a very clear wording that a document made for a bank robbery would not be protected by copyright law. And the second case is actually more recent. It's from the CJAU, and it's Public Resources Org. And this document, this decision talks about the overriding power of the public interest in these disputes. So the overriding public interest to overcome copyright protection, in this case of access to standard documents and free access to these documents. And this public interest talks also a lot of morality and public policy, since both of these concepts are there for the public interest. So with this transversal view of morality within the main IP branches, at least, we are starting to think, can morality do more than that? Can morality be more to IP than to simply exclude creations and inventions from protection? And that's why we are starting to rethink morality within IP law, and Giulia will continue.
Thank you so much, Amanda. Stay here so that people can compare our accents. You do all right. Yes, I mean, setting the scene in this stellar lineup of speakers is not easy. And let me also add a caveat. I hope Amanda allows that because it was not part of the rehearsal. But for me, being back at ATRIP is particularly nice because it has this magic of bringing me backwards and forwards at the same time. So it brings me forwards because it stimulates me, but I'm here recalling my first ATRIP presentation in 2019, where under the topic of can we talk about an essential function doctrine in copyright, I showed a slide very visually, graphically visualizing that we were talking about capture effect in IP law. And I think I could have used the same slide with a different topic today, because we are this time intentionally, Amanda and I, sharing with you this research that stems from the question, could we intentionally capture morality to do something in IP law? And that's what Amanda was presenting as we started considering possibilities of rethinking morality, since it's something that we can juggle with. Now, we have been diligent, I would say. We did our homework, and we looked at the classic example of normative options to use a concept that we do know it's a delicate one, but to use the concept and try to find possible fits or matches within the IP legal systems, just asking ourselves, do we want to expand something in morality or restrict? Do we want to embrace classic normative options of rethinking some rights or shape morality as a right, as a duty, as a power? But what we are presenting to you today is the most recent state of our research, that are three options that we find particularly matching the characteristics of the IP legal systems in general. So I will not create too much suspense. Amanda explained to us and showed to us that morality exists in IP law right now as a mechanism to exclude subject matter. And what we are bringing today to you as a brainstorming altogether is that morality could have a different shape if it was something affecting the limitations or exceptions or flexibilities of IP rights. So not excluding something from subject matter, but allowing that subject matter to be protected and using morality as an horizontal criterion to apply limitations to the exercise of those rights. The other two options we have in mind, and they are getting a little bit more complicated to do in IP law, are starting thinking about morality as a defense. That sounds kind of the same vibe as morality as a limitation, in the sense that we don't touch the subject matter, we are looking at flexibilities, but we are a little bit more outside the black letter law. You will see in the next slide the example of how can we use morality when we don't have, for example, in the European scenario, an exception to copyright, and we may have, or a judge may have an idea as an additional defense external to the IP system. And the third and last point we've been researching now for some time is, could morality become part of the rule in IP law? And I think I will not spend too much time here because I really want to jump to the examples that we prepared for you. But I think this point of morality as part of the rule also relates very well with the explanation of Article 3 that we had with Professor Francesca Papadopoulou, because it comes from, actually, we had the idea from obligations to disclose more information. So we heard a very good example just a bit ago. So we prepared some examples to you to convey better what are our ideas right now, and they are all examples linked to sustainability. So why we are starting to be quite happy with this research, I would say, because in the focus on sustainability, this open question, could rethinking morality be something useful, seems to allow us to move on quite several grounds. So the first one is morality as a limitation, right? I was telling just now, as an horizontal criteria, overcoming some long-standing problems in the IP flexibilities, for example, in copyright law. Now, we were looking at the Berne Convention, and the three-step test could actually be morality impacted if we use morality more or less explicitly as an entry point to add in the black letter law, maybe. So here we are almost advocating for a legislative reform internationally, being very ambitious, but add the entry point to add a mentioning of the legitimate interest of society as a whole, and not just of the author, of the right holder. Now, because I know that I have 3 minutes, I'll just give you other examples to poke your mind and collect your feedback. That is morality as a limitation, the closest we have in our current legislations. Morality as a defense, I was mentioning to you before, the exercise of IP rights has its own room and carve-outs for flexibility. However, some scenarios are really complicated to tackle. So we were thinking together, what about refusals to license works or inventions on racist grounds? Can we all together, us as academics, but also as legal interpreters, can we all decide that that's because of morality that we permit that use? Discriminatory behaviors when it comes to essential drugs, for example. Could morality be the defense that intellectual property embraces with a capture effect to solve some of its internal problems and to move towards sustainability goals? And finally, and that's why I was referring also to previous presentations, could morality become part of the rule when we are already seeing, for example, being based in the European Union, we have been studying a lot the new proposed EU Green Claims Directive. Now, in that directive, exactly like the WIPO recent Treaty on Genetic Resources, what we are doing is interfering with IP legal systems by imposing an obligation to disclose more information. Now that's becoming part of the rule. I can get you a green trademark, but you need to tell me more about your sustainability practices because it's a green one. Now, we were actually surprised by connecting the dots and say, wait, is it already happening that morality has already served as an entry point? we couldn't find explicit mentioning of that as a reasoning. That's why we wanted to bring this to you and discuss together. I think there is some creativity in our research, which is not published yet, so that's why we are here. Please do share questions and concerns. When it comes, for example, to design law, we try to follow the same rule, the same idea of morality as a rule, and we were asking ourselves, could we ask more or ask applicants for design protection to disclose more about the context of the design, because we have been studying a lot and working a lot, for example, on design architectures that end up, if used in a public space, end up being not accessible enough for disability, for people with disabilities. So should we use morality to do more than just the proposed EU Green Claims Directive we are studying? So on this note, I do conclude, but I wanted to share with you also one thought. That is, Amanda and I have been absolutely flattered to be invited in this panel, and very happy to be here to continue our study with all the audience. And we were somehow surprised and not surprised by not seeing the word morality in the program, but somehow understanding it beneath all the presentations. So that's why we really look forward to the discussion and the questions. Thank you so much.
Thank you very much, Amanda and Giulia. Yes, ethics, morality, yeah, there's a bit of an overlap. We can't have a discussion on philosophical aspects on that for now. But do I know? Okay,